The man accused of killing conservative activist Charlie Kirk was back in court Friday as a judge ruled on a key issue in the case. Now, the judge denied a defense request to keep some court documents private, saying there wasn't enough justification to hide them from the public, but the judge did leave open the possibility that parts of a future hearing could still be closed. You see, that hearing, scheduled for April 17th, is going to focus on a key moment: whether TV cameras, microphones, photographers should be banned from the courtroom. Defense attorneys argue that wall-to-wall media coverage can make it hard for the defendant to get a fair trial. Prosecutors, news organizations, even Kirk's widow say the public has a right to see what happens, I would say, particularly in this case. 22-year-old Tyler Robinson is charged with aggravated murder in the September shooting at Utah Valley University. Prosecutors say DNA evidence, messages, surveillance footage links Robinson to the killing, and they are planning to seek the death penalty. Although Robinson hasn't entered a plea yet, there's still a lot we got to get into. So I want to bring in trial attorney Mark Geragos. He's also the co-host of two popular podcasts, Reasonable Doubt and Two Angry Men. Thank you for taking the time. Big picture here, the way I see it is I would normally agree with you and say, you know, cameras in a courtroom, even though I cover trials all the time, I can understand sometimes it might affect defendant's right to a fair and impartial jury. Everybody knows about it. But there is something about this case where there's so many conspiracy theories and so many rumors that is there not a value for the American people who already have a right to public access to trials in our legal system to really see what the evidence is, to get an understanding of what this case is really about?
My reflexive answer is yes, I do agree with you. And if you had asked me this 15, 20 years ago, I would have disagreed with you. Having gone through my fair share of what I call supersized trials, I used to think that if you didn't have cameras in the courtroom, that would damp down the enthusiasm, if you will, and kind of the circus-like atmosphere. It actually counterintuitively has the opposite effect. What ends up happening when you don't have cameras in the courtroom, you get this giant game of telephone tag where people who are not in the courtroom are commenting on it, are telling you things that is filtered through 1 or 2 to 3 degrees of separation. And it's not healthy because unless you're sequestering the jury, that stuff gets back to a jury.
It's a good point. I mean, look at Diddy, look at Harvey Weinstein. It was all like word of mouth and written reporting about what was going on. What do you think the judge is going to do here? And whatever the decision is, could it be appealed? How do courts generally, review these matters about cameras or microphones in the courtroom?
So far, if I'm reading the tea leaves and I'm going to go out, I wish there was a betting line. I would bet that he is going to allow cameras in the courtroom. Every decision he's made so far telegraphs to me, at least, that he's going to do it. The fact that he has telegraphed that he's going to at least think about closing parts of it is because he wants to let the defense make the argument. And then I think he's going to say, okay, I listened to it, I'm not convinced, and he's going to say the public's right to know, in this kind of tension between the First Amendment and the Sixth Amendment, and he's going to say that all things considered, he's going to rule on letting this be open and the public seeing it.
Mark, I'm not going to lie to you. Based on the prosecution's documents, it feels like a pretty strong case. I mentioned the surveillance, DNA, the messages allegedly from the defendant. Where does the defense attorney go here? Are we starting to see it? Hey, listen, let's try to fight, that there should be no cameras in the courtroom. Let's try to fight that he can't get a fair jury. I mean, this is going to be a very high-profile case. It already is. The shooting of Charlie Kirk was amplified across the entire nation. Where does defense attorneys go in something like this?
Well, remember, this is a death penalty case. And in a death penalty case, and you've seen that they've got very able defense counsel. And if you look back historically on death penalty cases, there's 2 approaches. One is you fight the battle on the guilt phase. There's usually 2 phases to a capital case, a guilt phase and a penalty phase. If you fight the battle on the guilt or reasonable doubt phase, merits phase, that's one thing. If you, however, after doing your investigation, after going through, turning over every rock and looking and following every lead, if you determine, look, this thing, I don't really stand a chance, then what you do is reverse engineer how you're going to try the merits or guilt phase with an eye towards mitigation. And that has worked very effectively in the past. I can think of 3 or 4 trials where the defense lawyers were very successful in a case that looked at daunting and overwhelming in the evidence and ended up engineering either through a trial or on the eve of trial, take a look at Idaho, getting a plea that spared the client the death penalty.
And I'll also tell you, even in the most egregious or brutal cases, a jury is not going to automatically come back after a conviction and say the death penalty. I mean, look at the Parkland shooting case. I think that's a prime example. So really interesting, a lot of different things happening here. Mark Geragos, great seeing you. Thanks so much. Have a great weekend.
Good to see you, too.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.